House Bill 324 and recognize Representative Johnson.
Thank you, Chairman Smithy, Vice Chair Wu, members of the committee. I appreciate very much the opportunity to present House Bill 324, or also known as the Summer-Willis Act, who you will hear from this afternoon. The bill addresses critical gaps in our sexual assault laws, specifically around the issue of intoxication. Sheriff Louderback, I'm sure you are aware of that phrase of fight or flight, that you never know how people are going to react or respond in a moment of that kind of attack. And Representative Little, when you were before civil jurisprudence, you made this powerful statement with regard to victims of sexual assault and described it as soul murder. And we are seeing, unfortunately, in Texas, despite our efforts in the penal code to deal with the issue of consent, the Sex Assault Task Force Advisory continues to tell us we are not giving prosecutors the tools that they need to deal with the issue of intoxication or lack of consent to a point that can hold a perpetrator accountable and not put them in a position of effectively derailing the prosecution. Today, you're going to hear from Summer Willis, who has experienced sexual assault and rape, and she is going to tell you about the years of which she has made it her mission to tell people the trauma that victims come through and the fact that Texas does need to update our laws. You're also going to hear from Jana Oswald, who is absolutely an expert in this field from Harris County. She is on the ground in the courtrooms dealing with the challenges of these prosecutions to talk about the manner in which this bill addresses three critical issues: the incapacitation and consent, withdrawal of consent, and impersonating trusted professionals to obtain consent. Chairman, I'm happy to take any other questions. Ask that the committee gives a chance to these two witnesses and reserve the right to close.
Any questions? Mr. Little?
Thank you, Chairman Smith. Representative Johnson, I asked these questions with great temerity, understanding that this is your area of expertise. I spent a lot of time with this bill last night trying to really understand its effect, and the portion that I'm trying to really understand the most is dealing with what I'll call the rewrite of the mental state provisions within sexual assault. And one of the changes that your bill seeks to make is that the aggressor knows or should have known that the victim was incapable either of appraising the nature of the act or resisting the act. And I can understand how that would, how that provision would be engaged if the victim were drugged, too drunk to know better, somehow otherwise incapacitated. I'm looking at that provision and wondering, what is the real life on the ground application of incapable either of appraising the nature of the act or of resisting the act? What, in your experience, what are we fixing there?
I appreciate the comment, and actually what you bring up is probably the issue that we've dealt with for the last couple of sessions, that the House continues to pass this bill, but the Senate doesn't even take it up. And what we're asking for is reasonably should have known. And so, as most are aware in criminal law, we can't make the defendant confess. We can't make them give us a statement. And how do you as a prosecutor prove that the defendant knew if the defendant doesn't confess? And so what we're looking at here is the circumstances of the facts to show that the defendant reasonably should have known based on the fact pattern is there. And part of this here, and you've seen this recently in the news, with individuals that are intoxicated and have a question of whether or not they have withdrawn consent or have not, and you've had prosecutors say, hey, I can't make it fit into the existing provision or statutes of consent to let the jury make the determination. And you're right, Representative Little, part of this is, and I do have a prosecutor here that can answer on the ground examples of where it's happening. The problem that we're seeing is despite prosecutors' best efforts to address the issues of the victim, to get it in front of a jury, for them to make the case-by-case determination under the facts, if it was a circumstance by which a reasonable person would have known that they either withdrew or didn't have the capacity to consent. When you flip that into not what we can see the defendant should have known, but that the state has to prove what the defendant knew, it puts all the power in the defendant.
I see your point. The other thing that I looked at with some great interest was the modification to the, call them vulnerable persons provisions. You're pulling within the ambit of the statute people who impersonate a public servant, impersonate a clergyman, impersonate a coach or tutor. Does that happen?
Yeah, all the time. I wish that wasn't a real thing, but there are lots of folks that like to walk around and pretend to be cops or pretend to be other clergy or anything else. And so when people think that they're effectively giving consent to somebody that's an authoritative figure, and I've asked the same question, why don't we just allege fraud and that there wasn't really consent? So I would liken this to like aggravated assault, deadly weapon, where by statute we say if you have a gun, if you have a knife, you don't need to prove any more than that. The jury can make that determination. We are effectively, as a state, saying if you are impersonating this individual or authority figure, it has the same effect.
Yeah.
And so we're trying to shut off the fraud.
But the problem is that if this were an actual clergyman or an actual mental health services provider, the liability is automatic. Whereas if you're just saying, well, I'm not actually one, I'm impersonating, you don't fall within the ambit of the statute yet.
You mentioned liability, and so when you say that, I think of civil. So I want to make, we're still
Criminally
talking,
liable.
Yeah, criminally responsible. So yeah, what we've done is the one thing I can tell you about perpetrators, they will pick the vulnerable group. Whether it's in a church camp, whether it's in the mall, a perpetrator knows how to pick a vulnerable person. In many circumstances, vulnerable people may come before clergy, other healthcare professionals, and they're there seeking support and advice. That's the kind of relationship by which that other individual has some ability to not only display, and we've heard it. We've heard about religious individuals that have indicated, I've heard about it to married spouses, that having sex with them was going to better enforce their relationship with God. Now, that sounds shocking that it would come from somebody that is trying to portray themselves as a man of God, but those are real scenarios. And so we're just taking that one level further, that for the people that are perpetrators that know that that important relationship with somebody like a counselor or a clergy or a coach or a tutor is somebody that gives you a pathway of trust, that even worse, if they're impersonating that pathway of trust to get them to comply with sexual assault, we're not going to give them that get-out-of-jail-free card.
Okay. Thank you so much for those clarifications.
I appreciate it. I reserve the right to close unless there are other questions.
Ms. Jones had a question.
So I was trying to follow the conversation. I actually like the little tag team thing that Rep. Little and I do, but I was trying to follow what you're concerned about, because I'm a detail freak. So can you just tell me where you were looking that concerned you so I can just have that for my notes?
Let me turn my microphone back on. Excuse me. So this is the modification to 22011B of the Penal Code. So as we're,
The page and
I'm sorry, I printed it in a letter. I imagine it's going to be on one or two.
So
but
Representative Little, if I remember, it was the impersonation. And
no,
so-
the major the concern that I had was beginning with B3. It says the actor knows or reasonably should know. I have no problem with or reasonably should know. The other person is unconscious, physically unable to resist. And then C, incapable either of appraising the nature of the act or of resisting the act. And I'm trying to understand what that means and what its application is here, because the way that I read C, incapable either of appraising the nature of the act or of resisting the act, or D, unaware that the sexual assault is occurring, I see that as a significant expansion of the, I call it
So if I,
aggressor's mental state.
so the concern is the mental state of the victim. So if the victim has been drugged, right? So if you have been drugged to the point that you can't either physically respond, verbally respond, we're dealing with those scenarios of where any individual in some circumstances are incapacitated by another. where somebody else roofies them and then somebody else takes advantage of them. That's a circumstance where it would be almost impossible for the state to prove under the existing statute.
And can I ask a hypothetical that I think would be relevant? So you have an assaulter who assaults a victim. The victim says, I was drunk. Anybody would have known I was drunk. And the person who's been charged with the offense says, well, I was drunk too.
Yes.
And so is that person possess the appropriate mental state under your proposed change? And is there a difference from the current state of the law in that regard?
That's a great concern, and it is one that I've also thought about, and I will say there is a big difference between regret and rape. And that's why you want good prosecutors with the tools to be able to evaluate those facts and make decisions. But voluntary intoxication is not a defense under criminal law. That's why DWI is a crime.
Mm-hmm.
You go out and drink too much and drive a car and run somebody over. We don't allow you the defense to say, I'm sorry, I was drunk. If we don't allow the defense in hitting somebody in a car, how could we equally allow them effectively to say that on rape? And that's part of the challenge. It's not a defense under the law.
Mm-hmm.
But it's currently, because of the state of the victim and their intoxication, effectively becoming like a get-out-of-jail-free card for the perpetrator.
That's what I was wondering. Thank you,
You're welcome.
Representative Jones.
Thank you.
Sorry.
So you said something that I now have a question about. You said if you're incapacitated by another. And-
Right now, we're not catching that.
Right. So that's somebody roofies me or something like that.
Or one person roofies you, another individual takes advantage of them doing the act of incapacitating you and taking advantage of you.
So I've got two questions. The first question is, how do I know if somebody roofied you? Like let's say you're roofied.
Yeah.
And then I do something to you. How is there a requirement that I know they roofied you?
No, and that's why you're looking at if a reasonable person in this circumstance would have recognized this was not somebody that should have been sexually assaulted. This is not somebody that was consenting. And that's why the challenge is, it really is about giving prosecutors the tools to have available in a fact-by-fact situation to be able to have the leeway to be able to get this into a jury.
Then another question, why does it matter? Like, let's say the person drank too much and they're literally incapacitated, right?
And they pass out on the
And
floor.
they pass out on the floor.
That cannot be implied as consent.
There's no consent.
Okay, I just
Right?
was,
So,
okay.
and the question right now is, we are putting too much of a burden on the victim to somehow prove that they didn't consent. We're trying to shift this to recognize, just because you see a drunk college student incapacitated at a frat party, that doesn't mean you can,
Say it's
Or laying
easy
on the
pickings.
and that's the point. It's easy pickings. And right now, despite the fact that Texas has tried, and we've got some laws around the issue of consent, we're not capturing the full breadth. And I will say, just like we do we saw Ms. T come up here every 2 years on human trafficking, I hate to tell you, perpetrators, when they figure out there's a loophole they can exploit, they for damn sure exploit it.
That's right.
Okay. I think I understand. And if I have any more, I'll just come to
Please,
you.
and we have this amazing prosecutor here today that can answer this stuff better than I can.
Mr. Money?
Thank you, Ms. Johnson. Thank you for working on this important issue. I think over the last 15 or 20 years, this is one of the scariest scenarios that I read about in the news. Thankfully, I'm not in criminal law, so I don't have to prosecute or defend cases like this. But there's horrific stories on both sides. And so I'll use Representative Little's word, temerity. I'll step into this not only because of my lack of legal experience, but just the sensitivity of the topic. And my concern here is I've got layers of concerns on both sides because I want to solve the problem that you're solving, and I don't know where I am exactly on this bill yet, but Ultimately, a judge or jury is going to have to prove beyond a reasonable doubt these things. And so you back up and you already have a situation in which if a crime occurred, it occurred in an intimate setting where usually there are no other witnesses or any evidence other than the defendant and the victim explaining what they think happened. You have usually in both cases alcohol. I appreciate what you said about voluntary intoxication. That's true, and I would encourage everyone to not go to the frat party and get drunk and look to carry some, to go home with someone. But in that case, you have alcohol. You have consent, which in intimate settings, whether there's alcohol involved or not, is sometimes murky, and it can be given and withdrawn at various times. And then you have a knows or reasonably should have known standard that it complicates it even more. And so all of that being said, I do not want any young woman to ever, or old woman or person, to be taken advantage of, whether they have had a drink of their own volition, have been slipped something by someone else. I mean, people should be protected from sexual violation in every respect. I also don't want someone to be accused and convicted of something that is
I get it.
difficult
going,
and
but I get it.
murky.
Yep.
And so I want to know, and I know this may be for the prosecutor that's going to come up and talk, like in real life, in real situations, how do we know that this gets us somewhere where we have him saying, I didn't know that she withdrew her consent, and she says, well, you reasonably should have known that I withdrew my consent. And he says, that's not the way I remember it. I mean, does this really even get us closer to anything that we can prosecute beyond a reasonable doubt?
I do, and I'm going to have the prosecutor speak to some of those examples. When you ask me this question, I feel the same pull that I felt with Representative Little, that I don't want a pendulum to swing so far the other way that, let's just look at the power dynamic here. We are typically talking about women as victims, male as offenders, but that's not always the case, right? And I don't want that to be where, we all think about college and the rite of passage of the drunken parties and everything else, but we can't make the rite of passage also rape.
Right.
And so part of the challenge here, when you said intimate settings, also people hold people up in an alley where there's no witness. And that's part of it. These are not always intimate settings. Sometimes these are settings that the perpetrator puts in place that there is no witness, there's no ability to have a witness, and you are taking their word versus the other. Or we are seeing the manner in which people are being incapacitated. I will tell you one other story. When I was a prosecutor and somebody was insisting that they wanted a case filed, they had met up with somebody when the internet was new. They had gone to this gentleman's apartment. They had taken a bath in his apartment. Those people ended up having sex. A couple days later, he hadn't called. She talked to a coworker, and a coworker said, well, maybe that's rape. That's not rape. That's regret. And I am very mindful. I do not want to do anything here that would allow for false accusations of rape to be equally taken advantage of. I do trust many of our prosecutors, and all I can tell you is, unfortunately, right now, despite our best efforts on the consent language and based on our sex assault task force, we are missing a component of perpetrators that are now taking advantage of our failure to fix this in the law. But I do want our prosecutors to have tools. I don't want them to have a weapon that shouldn't be used in a bad way. And so I'm happy to talk to you about it. I get it. But it's also why the law requires 12 individual people unanimously to determine that they believe beyond a reasonable doubt. That hesitation or that question that would benefit the defendant, I do believe is built into our standards. Not saying I want to take advantage of that by any means. I just know we have something lacking, and I'll be happy to answer more after the prosecutor gets a chance to talk about some of the scenarios that we're seeing, if that's okay.
Okay, thank you.
I appreciate it.
Vice Chair Wu had a question.
Hi.
Could I, do you mind if I run a scenario by you?
Sure.
Okay, so let's say.
If I can't answer it, can I leave it from
Yeah,
Ms. Oswald?
absolutely. I
Thank you.
think you will be, though. Let's say an elected official has a staff and has a lot of young staffers, and that elected official invites a young underage staffer,
Go ahead.
and that person plies them with alcohol, has them drinks themselves too, but plies them with enough alcohol that they are obviously intoxicated and unable to consent, and they have sex, right? Would that scenario fall into, like, this law?
Well, I have to say, until you raised that question, I had not thought about that scenario in this particular circumstance. The question of whether or not there's an issue or lack of consent is always a question, and that's why I think people need to be able to have the tools to determine. And so all we're doing here is making sure that prosecutors have the opportunity to evaluate each case on the merits.
But,
Thank you.
thank you.
Thank you. So is there
Thanks,
anyone
Chairman.
you want to call first as a witness? Oh, I'm sorry. Ms. Jones?
When I had intended to ask you something, when you first started your layout, you said there were 3 issues. You said incapacitation, withdrawal of consent, and what was the third one?
The impersonation of a person that's a kind of trusted authoritative figure. And
Okay,
that's why
then-
we created the impersonation, as opposed to you are one, you're making people think you are one to garner their trust.
And then the next question I had was, you're shifting the burden from,
Not shifting the burden, I'm acknowledging the fact that where we currently are, where we have to prove that the defendant knew, that puts all the control in the defendant, that if they don't confess, how do you know that they knew? How do you prove that they knew in that, quote, intimate setting where there is nobody else? And that's why the knew or reasonably should have known allows an opportunity for a jury to look at a broader fact pattern as opposed to putting the onus on the defendant to admit that they did wrong or not.
okay, so I just want to make sure, rather than say intentionally, what does it say, intentionally, knowingly, and why can't I remember the
It
third
says
one?
new. So if you
No,
look
no,
at
no,
the
I'm saying,
statute,
right, no, I'm saying just, in most criminal cases,
Yeah.
it's intentionally, knowingly, and.
you still have intentionally knowing to commit the
Right,
act. What we're
right.
talking about is the breakdown of the
They knew or
subsections that
should
talk
have
about
known.
consent.
Okay,
So we're really talking about the sections that we already have there on consent, where it effectively says that the defendant knew that there was a lack of consent. We still have to prove intentionally knowingly committed the crime. It's just that knowing of consent element as to the individual saying, I didn't know, or not confessing.
so you cleared it up for me.
Okay.
Thank you.
You're welcome.
Yes, Ms. Moody?
And I do, to crystallize this, and this has been a conversation we've had for several sessions, I think going back to 2017 now. And to your point, Representative Johnson, the conduct we're talking about, and I mean, obviously anybody can go read the code provisions about the actual physical conduct we're talking about. In these instances, and what you've got in your amendment going to be section B that refers back up to A1 is where we're going to say consent doesn't exist. Now, there's still evidence that's going to have to be proffered to any of these points where you're saying that consent cannot exist in this circumstance. So it made me think of you have this, because you've got the provision about if the person is, let's see how you have it worded, the intoxication, right? The actor knows or reasonably should know the other person is intoxicated by any substance such as the other person is incapable of consenting to the act. The law as it is now, I always equate it to like stumbling upon the drunk person and going, well, I didn't do it. Because the way it's written, now is the actor has intentionally impaired the other person's power to appraise or control the other person's conduct by administering any substance without the other person's knowledge. So you have to be the one. You have to be the one to do that, to take the question of consent away. Think about the very notable case out of France, right? This is the husband and wife. I don't know if you've heard of this case, right? Husband and wife, where I think it's multiple rapes. Husband inviting hundreds of people over, and he's drugging the wife, and I mean, this is for a very long time. And some of the defendants in these cases said, well, we didn't know she didn't consent. Like, we were being invited over there, and the husband was saying this was okay. And so, I mean, you think about, I know this is a very, like, this is kind of what I'm trying to say is, like, this is a very, very, like, over-the-top example of what consent arguments could be about. But think about it from that perspective. That is something that anyone walking into that room should know, or through any reasonable person would know something's not right here, and they shouldn't be, like, the issue of consent should no longer be an issue in that particular case. And so while that's an extremely egregious case, I think it kind of crystallizes where the consent issue is the crux of many of these cases, particularly adult relationships that have formally have had consent. Those are the most complicated, right? Where you've had, I think one of the hardest cases I ever tried was former relationship, adult consenting relationship, former sexual relationship, and then that pivoted to breakup and rape, right? The jury is going to have a very complicated time with that. And so those are the cases where these types of measures can help shine a light on whether we think under the law consent is present or is not present. And it's not to say that these are de facto, right? You're going to have to enter in testimony about these things. Ultimately, the facts, I guess I put it this way, the facts of these cases aren't going to change in what's being presented. The lens, which is on the jury's eye, is going to change in the way that they interpret the facts that we either say consent can be present or not. So we're taking the lens and changing the lens by which they're going to view the same conduct, and I think that it starts from a point of these acts at their core need consent of both parties. And how do we reflect that in our law? I think Mr. Money's concern about this is very real, because these are prosecutions that can be weaponized, and so you do need to be careful. And I'm sure we'll hear from witnesses that'll talk about, because we've heard from them before when we proposed this type of legislation, how this could possibly be abused. So we need to be certainly need to be conscious of those issues. But to your point, and I don't have the numbers in front of me, and you know them probably, but number of sexual assaults that occur that are never reported, those that are reported, and then go up to those that are finally prosecuted, those that people are convicted, right? It is limit at every stage. You have so many that are not even reported. So there is a problem baked into this system that this bill is trying to get to the core of. But we do need to be mindful of the guardrails on it. But I appreciate you bringing this and continue to further this conversation that we've been having for a bit now.
Thank you, Chairman. Thank you, Chairman.
Ms. Bowers has a question.
Thank you, Mr. Chairman, and thank you, Representative Johnson. I've got a few questions that deal with consent and intoxication cases. How do you envision prosecutors establishing intoxication levels respectively in court, particularly when BAC tests aren't administered in time? That's my first one.
I mean, just like when we try a DWI and we don't have a breath test, we look at the facts around the scenario to determine the level of intoxication, right? You've all been at a party where you can see somebody that's had a couple drinks and is starting to get buzzed, and somebody's got the lampshade on their head, is on the verge of passing out. And again, I think that's the question of the intoxication to a point that each of us probably have that monitor of which you would say, okay, you've gone too far, or it's gotten too far. And that's at least what this does, is give, and we're not requiring a breath test or a sample or a blood sample of where your level of intoxication is. You might have it if you've got somebody that actually went in and did a SANE exam and has the toxicology for that. But otherwise, it's a fact-by-fact scenario where you are trusting that the prosecutors are making the right call on those facts, and then ultimately you are giving it to 12 people to equally use their own common sense and their judgment to say for each one of them, is this something that would have been at the line that you think meets this definition of intoxication to the extent that they're not able to give effective consent or withdraw it.
So then that leads me to, as you said, the provision regarding withdrawn consent. Can you explain how you see this being proven in court? I think you shared this a little bit in your explanation of what types of evidence might support these cases. I think you've answered that a little bit.
I mean, I think you're going to be really dependent upon the victim and the witness. And I mentioned what we see in many circumstances, fight or flight. There are some people that in a traumatic event, they're going to fight back. But there are some that freeze. And that's the challenge. If somebody starts beating up and clawing their eyes, we're going to go, oh, yeah, they didn't want it. But equally, when you look at the neurobiology of the brain in trauma, your brain is going to try to help you one of two ways. It's either going to say, fight like hell, and that's the way your brain responds, or your brain is going to freeze, and then your brain is going to try to help you forget. And so there's a lot of neurobiology on trauma, on how we do these investigations, and a lot that we have had to learn over the last decade, that not every victim looks the way you would expect. And that's why, for that individual that freezes in that moment, again, we're turning it on that situation or that reasonable situation. Is this somebody that is a willing participant in this exercise, or did somebody go somewhere they knew they shouldn't have gone?
And I would add, you don't know in that moment how you would respond. You know,
You never
my
know.
instinct is telling me I'd fight like hell, but hell, I don't know what my response would be. So thank you for this. And, the last part, I think, is because some constituents might be concerned about potential impacts on dating and relationships. So how would you respond to concerns that these changes might criminalize misunderstandings rather than malicious acts?
I think, again, you're trusting, just like we tell every juror when they come in and we say, look, you didn't check your common sense at the door. We've all been in dating relationships or know people that have been in dating relationships that can talk about however they want to talk about how they got connected with their folks or not. Again, I think when you look at the examples of what we're talking about on sexual assault, oftentimes perpetrators, every victim I know feels shame. Every victim I know thinks they did something to deserve it. Whether it was smoking a joint as a kid or drinking too much, going to the party, wearing a skirt they shouldn't have worn. Every victim beats themselves up first because no woman wakes up every morning and thinks today's the day I'm raped. So we all feel a denial of they must have done something to put themselves in a position I wouldn't. And victims feel that too. There is so much underreporting. There is so much shame. Again, in this circumstance, we really are talking about not sexual promiscuity, not regret. We're talking about rape. Rape that is being hidden by the law right now, allowing the perpetrator to control the prosecution. And that's why we're asking for these changes based on what we're actually seeing in the courts.
Thank you so much, and thank you for bringing this
appreciate
piece
you.
of legislation
Thank
to
you.
us. Thank
Ms.
you.
Jones?
So when I was in college, I ran track. And I was a freshman. And I was in the track office, and one of the upperclassmen, my teammates, was there, and he was really popular, and I liked him, not liked him like I wanted to date him, like I liked him. I thought he was cool. I thought he was trustworthy. And it was just us in the track office. And he comes on to me. I ask him to stop. I didn't fight him. I mean, prior to this happening to me, I thought I would have fought, but I didn't. And all these things were going through my mind. And then he forced himself on me, and I just sort of laid there. I just sort of laid there. I didn't really know what to do. I didn't know how it happened. And then, and it happened. It was weird, uncomfortable. And I didn't say a word to anybody. My roommate, 2 years later, encountered this same guy, and he tried to do it to her. Except for he wanted to tell everybody she was promiscuous. She was not. But it was a way to stop people from believing her. And amazingly, I stood up for her. I said no because he did it to me. So when people talk about how you respond when stuff like that happens, people look at me. I mean, I'm a big girl. I'm a strong girl. But people would say, well, Yolanda, you never would let somebody do that to you. I am telling you, under the right circumstances, anybody can be raped. And you just don't know how to protect yourself. And when people came to me afterwards, because they were trying to figure out why I was picking like the freshmen, so I guess there was a pattern that he chose freshmen. Why I was standing up for a freshman over, by this time he graduated and was just training there. So it's hard, because some people will say, well, you should have said something. And so I actually, when I think about it, I like the bill because it protects people who are like me. That's all I want to say.
Thank you for sharing.
Okay, thank you. Mr.
Representative Johnson, thank you for bringing an effective tool for prosecution. Thank you.